Good evening, everybody. Hello, welcome, welcome, welcome. Hello, hello, hello. Welcome in, everybody. We've got back at my normal time, 7 o'clock. So welcome in, everyone. Hello, hello. I do have comments off while I read the transcripts tonight. I will turn them back on for a Q&A session after immediately following. So you'll have to stay tuned for that. But tonight, I am planning to continue on with Michael Cohen's cross-examination. Michael Cohen was on the stand for several days. Thanks, James. So I will not be able to read through all of his cross-examination. That's just too much. But I will do the cross-examination regarding this phone call situation that was the big to-do, and then I will move from that cross into his redirect. So I do plan to read through the redirect so that we have plenty of background information before we get into any further testimony. So there were several sidebars, everyone, and I will read through those sidebars. I think that information is very important, but we are, of course, moving forward here, and we have a wonderful sketch here. I think this is my personal favorite here. We have of Judge Rashawn. So I will be getting, I'm hoping to get through the last piece of Michael Cohen's cross-examination tonight so that we can move into the last witness that was testifying, and then moving forward from there. With that, it's very interesting. But I will be skipping through a bit tonight. Again, I will just be doing a section of when Mr. Blanche is talking to Mr. Cohen about a specific phone call, and then I will skip forward after that. So I will be kind of fast forwarding a little bit tonight, but stay with me. I think it will be very interesting and informative. So welcome in, everyone. Glad to see you all. So as a friendly reminder, at the very top of the page, we have the name of the person who is being questioned. So this is our witness here, Michael Cohen, and this is the cross-examination, and it's being done by Mr. Blanche here. So I am going to pick up on page 3869, which is quite a bit further down the road than where we left off. So I find that I think this will be the best place for us to kind of get started. Hello, VC. Welcome, welcome. Hello, Kristen. So we will start here, and it may seem a little bit odd, but we're just a couple of pages away from Mr. Blanche's big aha moment, apparently. And this is really important because when we're redirecting, when we're going through this whole process, this cross-examination portion is very important. So I will go ahead and dive on in, everyone. I'm hoping to get through, again, this particular piece of his cross-examination, and then a lot of the redirect, the recross as well, so that we can kind of keep the ball rolling here. So with that, everyone, welcome in. Again, I will turn comments on after I have finished reading tonight, just so that, it's hard for me to see the comments while I'm reading. So we will go ahead and get started. Welcome in, welcome in. All right, so here's our question. Again, everything in orange is going to be Mr. Blanche for the defense. Everything in green is our witness, Mr. Cohen. Anything in pink is the court. Anything in blue is the state of New York. So here we go. You still, even after November, were still looking for a position in the White House, correct? Yes, sir. No, sir. I was looking for that same title as personal attorney to the president. Well, at that point, did you switch from wanting to work in the White House as special counsel or general counsel's office to wanting to be personal attorney? I didn't want the general counsel's office. I made that crystal clear. I always wanted the title personal attorney to the president. I always said that there was no shame in being personal attorney to the president of the United States. Well, early in November, Mr. Cohen, there were no communications about personal attorney. All the communications were about whether you would be chief of staff and then special counsel to the president in the White House, correct? That was for my ego, yes. Well, 2 questions ago, you said you always just wanted to be the personal attorney, but I'm looking at the text messages in November where you're not talking about being personal attorney, Mr. Cohen. You're talking about wanting a job in the White House as special counsel to the President Trump, correct? No, sir. If you look at the text, my daughter, I turn around and I state to her that I'm not the right person for chief of staff. Also, I would not expect that I would be attorney general because it isn't within my qualifications. But you did think you were the right person to be special counsel to President Trump. You told that to your daughter, correct? Personal attorney, too, with Donald J. Trump is what I wanted. Later on in the text messages, you see the clarification in that title name. So later on, meaning in December or maybe January, you clarified to your daughter that what you meant in November is that what you said. My daughter used the title that I had at the Trump Organization. It was always supposed to be personal attorney to President Donald J. Trump. Are you familiar with someone named Gary Cohen? Yes. Who is that? Gary Cohen was the former president of Goldman Sachs. And when you say former, did President Trump appoint him as the director of National Economic Council? Yes. That was in the same period in between the transition? The transition, yes. You were frustrated that Mr. Cohen was named to that position, weren't you? I had asked for Mr. Cohen. Were you frustrated that he was named in that position? No, sir. You were not despondent that he was being given a White House role and you were not? No, sir. You testified, well, your testimony is that you never had a conversation with Mr. Davidson where you expressed frustration about Mr. Cohen. I stated, I don't recall having a conversation with Mr. Davidson about that. Do you recall, now we're in December now of 2016. Your daughter expressed that it was ridiculous that Mr. Cohen was appointed, not you, correct? Correct. And she also complained that you were having a hard time getting tickets to the inauguration ball, correct? I believe so. Your daughter said that President Trump and his new people were walking all over you, correct? Yes, sir. And you agreed with that, didn't you, at the time? At the time, you also agreed with your daughter that President Trump, and this is in December, isn't doing right by you in any way, correct? I was still waiting for the title personal attorney to the president. And ultimately, you got that title in January, right? Correct. But you were disappointed after all the work you had done for President Trump for 9.5 years. Nobody, including President Trump, offered you a position in the White House. And that's not accurate. You were not embarrassed that after all the work you had done for him, you were left behind his personal attorney and nothing more. That's the role that I wanted. In fact, I asked Gary Cohen, who provided me with the attorney Orrin Snyder, and Orrin Snyder and I, for about an hour, sat with President-elect Trump in his office, expressing the reason why personal attorney to the president was the exact role that I should play. That's the role that they gave me because this was the way that I could monetize that which I did. Now, do you know somebody named Daryl Scott? Yes. Who is that? Daryl Scott was my co-founder of the National Diversity Coalition for Trump. He is the pastor in Cleveland, Ohio. The only event that you attended during the campaign was at Pastor Scott's church, is that right? Yes. That is the one you spoke of? The New Spirit Revival Church. You were friends with Pastor Scott? We became friends, yes, sir. You knew Pastor Scott for years and years, right? Hold on, everyone. My lighting is not quite right here, so here we go. I knew him for more than a year. Well, did you know him in 2011 when there was some talk about whether President Trump would run for the presidency in 2012? I don't recall if he was part of that. So you recall only knowing him until the 2015-16 campaign. I apologize. I don't recall if he was part of the 2011, but I have known him for years. Did you all communicate on the phone? Yes, sir. Over texts? Yes, sir. And in person? Yes, sir. Do you recall expressing disappointment to Pastor Scott repeatedly that President Trump didn't bring you into his administration? Not into the administration. I knew the role that I wanted to have, and I may have expressed frustration, but I don't recall. Well, you don't recall, or let me ask it in a different way. Did you have communications with Pastor Scott? Yes, sir. Let me finish. about your frustration that President Trump did not bring you to the White House. I don't recall that. Did you have communications with Pastor Scott even after President Trump was in the office of the presidency about the fact you weren't working in the White House and you weren't a part of the administration? I don't recall that. Do you recall on National Prayer Day expressing frustration that you were sitting in your office and not in the White House with everyone else, all of the people that you had worked with on the campaign? Do you recall that? That I wasn't invited? Yes, sir. Do you recall talking to Pastor Scott about that? I believe so, yes. What do you recall saying to him? It would have been nice had I been invited, considering everybody that was part of the Diversity Coalition, people that I helped put together, were all there and I wasn't. But your testimony is you didn't say to him at that time, I should be working in the White House with President Trump. Not that I recall. Do you recall communicating with Pastor Scott regularly on the phone and over text, asking him to put in a good word with President Trump on your behalf? Yes, I recall that. I'm talking about 2015 and 2016. But even after the president was in the White House, do you recall that? I do. And your communications with him, this is while you were working at the Trump Organization and while you were a personal attorney to President Trump, correct? Yes. Your communications were to him in sum and substance were about putting in a good word with President Trump so that President Trump would bring you to the White House. I don't recall. To the White House? I knew the role again that I wanted. I had already had the idea in advance, which is what I expressed to my daughter. Why did you need Pastor Scott to put in a good word for you with President Trump? I knew he was going to be seeing him. While you're there, say something. What about during the campaign when you testified that you talked to President Trump almost every day? I did. Why did you need Pastor Scott to put in a good word for you along that time? It's always good to have somebody else advocate. What were you asking him to say to President Trump about you? How important it was for the Diversity Coalition as a basis for the campaign and its success. Do you recall in November of 2023, just a few months ago, your lawyer, not your lawyer that's here today, one of your lawyers applied for early termination of supervised release on your behalf? Yes, sir. As part of that application, do you recall that there were fake cases, meaning fake legal cases, included in the letter around that application? Objection, overruled. Yes, sir. And what was your role in that situation, if you could explain that to the jury? So as I was helping my friend who had just moved his law office for another attempt to submit papers for early termination for supervised release, I went on Google Bard, which is an AI tool, and I typed in a series of queries regarding the Second Circuit here in New York, decisions on early determination of supervised release. And the reasons, because in our papers, for whatever reason, I believe we had the Eighth Circuit, and it created a whole bunch of what they call, I think, phantom results, because AI wants to please the user. And I then provided to my counsel these 3 cases that were directly on point for why supervised release for me under the circumstances was just improper. And I provided it to him, and he included it in the document. And those citations were inaccurate, not the sum and substance, but the citations themselves. When you say inaccurate, the cases didn't exist, correct? Under the specific citation, correct. But that wasn't my question about the specific citation. My question was, the 3 cases that you gave your attorney were not real cases, correct? That's correct. And you knew that your lawyer was going to use those cases to support your application, correct? I gave them to him to use in support of the application, yes. You were an attorney. Well, by that you were disbarred. Yes, sir. You were an attorney for over 30 years? Yes, sir. And when you were a practicing attorney, you did corporate and litigation? Yes. Part of litigation is drafting briefs, correct? Yes. You did that? I did that. All right. I want to talk about something you testified about on Tuesday. You testified about a phone call on October 24th, okay, 2016. So that's 2 days right before you make a payment to the HELOC, and then you move money over from your HELOC to your LLC. Then you wire the money to Mr. Davidson on the 26th. Yes, correct? Yes. Do you recall testifying in response to conversations from the prosecutor about a phone call you had with Mr. Schiller at 8:02 p.m. on the 24th, two days earlier? Do you recall testifying about that? Yes, sir. Do you recall saying that you called Mr. Schiller on that evening because you wanted to speak to then Mr. Trump, right? Correct. You wanted to speak to President Trump to discuss the Stormy Daniels matter and that the resolution of it, that was your testimony, right? That was. Then you testified just a couple of days ago that you were successful. You called Mr. Schiller and you had a conversation. And in that conversation you were moving forward to fund the deal, correct? Correct. Can you explain to us how that works? You know that Mr. Schiller is with President Trump, and so that you know you can call his phone, and that Mr. Schiller just hands President Trump the phone? Yes, sir. Was he on speaker? Do you usually just have privacy with President Trump when that happens? Meaning, does Mr. Schiller put his cell phone on speaker and you talk to President Trump, or does he actually give him the phone and you have a private conversation? I've seen both. On October 24th of 2016, which one was it? I don't know the answer. I wasn't with them. Can you tell from your conversation with President Trump whether he was on speaker or whether you were just talking to him? I didn't take notes, so you don't recall either way? No, sir. But you recalled that on that call, I don't want to put words in your mouth, you discussed the Stormy Daniels matter and the resolution, and you also discussed the conversation would be that it was resolved and that you were going to move forward and fund the deal, right? Yes, sir. That was your testimony? Yes, sir. So I appreciate it was a long time ago, but would you have said to President Trump on that phone call, what would you have said? What would he have said to you? Objection, sustained. Do you have any recollection of what you said to him on that day? We talked about the matter, that it was resolved. I'm not going to hold you to exact language when you talked about the matter, that it was resolved. Is that the sort of thing that you would have said to him? Yes. I am sorry. How would you have said it to him? Objection, sustained. The point is, you have a distinct and specific recollection, do you not, that on October 24th at 8 o'clock, you talked to President Trump about the Stormy Daniels situation, correct? Yes, sir. Now, you testified in the grand jury last March, right? Yes, sir. You didn't talk about this phone call in the grand jury, did you? Not that I recall, no. Do you want me to show you the grand jury transcripts so you can check? Objection, sustained. When you say you don't recall, do you recall talking about this phone call when you met with the prosecutors before your grand jury testimony? Objection, sustained. Do you recall ever talking to the prosecutors prior to your testimony earlier this week about this phone call? Objection, overruled. I don't recall. So the first time that you recall having a conversation with President Trump on October 24th is at 8:02 p.m. is when you testified 2 days ago. No, sir. I just said I don't recall when I spoke to the DA about that specific matter. On Tuesday, you recall you were shown a particular call log between you and Mr. Schiller, and the prosecutor went right up to October 24th and said you had 2 phone calls that day, a voicemail and then a 1 minute and 36-minute phone call. Do you remember that? I do. You said that it was with President Trump. Mr. Trump, you said that. Yes, sir. And do you remember being interviewed on March 7th of last year in the district attorney's office, which was about a week before you testified, and not saying anything about this phone call? Objection, overruled. I said I don't recall. They refreshed my memory. Let me show you what's been marked for identification as B255. There are some notes from the meeting. You didn't take these notes, did you, Mr. Cohen? No, I did not. Do you see at the top the date March 7th? Yes. It started at 9 a.m.? Yes, sir. If we go to page 9, please, can you take a look to see if that refreshes your recollection that you didn't return the phone call? Can we approach? Judge, this is a classic Bornholt. He's not directing. It's classic People v. Bornholt. He is not directing his attention to where he was asked the question about it. I don't understand what the objection is. The objection is that you tried to impeach him with an admission, but you haven't established that he was asked the question about it. People versus Bornholt. Your Honor, that's not what this is showing. They walked through every day, and he talks about what he remembers for each day. As a matter of fact, on the 26th, which I'm about to show him, he has a specific recollection of a telephone calls with Mr. Trump. On the 23rd to 25th, there's a dash, verbatim writing on everything that he's saying. There is no question and answer. It's just giving an explanation of what he remembers, which is exactly why he may have not been asked the question. That's why we have Bornholt. to ensure the people are not impeached simply because they forget to say something. You have to establish that he was asked the question, that he was directed to a particular area, and that they failed to, given the opportunity, they failed to reveal it. Whereupon the following was in open court. If we could put that back up, 255, continuing cross-examination. Can you take a look at that, Mr. Cohen, and see if it refreshes your recollection about whether you were asked any questions about the phone call on the 25th? Yes, sir. Does that refresh your recollection about whether you were asked any questions about the phone calls on the 24th? No, sir. And you have no independent recollection of that meeting that would answer that question? I do not. Now, if we could look at the next page of those notes, if you look at the third line, it talks about calls between you and President Trump on the 26th, correct? 2 days later. Objection. Why don't you direct his attention and have him read it? Take a look at the third line. If you could read the third and fourth line, is there a question? Does that refresh your recollection that you did talk on that date about phone calls with President Trump on the 26th? Objection. Sustained. Do you have a recollection of talking on that day with the prosecutors about phone calls with President Trump on the 26th? Objection. Overruled. Yes, sir. And you did, right? Yes. Do you remember, I appreciate this goes back a while, do you remember at that time, October 22nd, 23rd, 24th of 2016, you were receiving a bunch of ongoing and continuing harassment phone calls? So somebody was calling you constantly. Do you remember that? Yes, sir. And do you remember that on the 24th at around 7 o'clock at night, the person who was harassing you forgot to block the number and you got the number? Do you remember that? No, sir. Let me show you what's been marked for identification just for you, the court, and the parties as B165. We're going to highlight some of this for you. So if you can see, this is just for you. But do you see the number, and that's you, and then the number that ends in 0594? Do you see that? Yes, sir. Do you see your text to this number that says, this number has been sent to Secret Service for your ongoing and continuous harassment to both myself as well as to the organization named on it? I do. That is at 7:10, right? Yes. And then the text back says, it wasn't me. My friend told me to call. I'm sorry for this. I won't do it again, right? Yes, sir. Then you respond and said, they're going to have to explain that to the Secret Service because you've been receiving dozens of these harassing calls over the past 3 days, right? Correct. If you are a minor, I suggest you notify your parent or guardian. That's what you said to them, right? I did. That person texted you back and said, I didn't do it. I am 14. Please don't do this. And you asked them to have their parent or guardian contact. Objection. He's reading from the document. Sustained. You eventually said you have their parent or guardian contact you. When they expressed they were 14, I felt it was proper. That was at 7:24 p.m. on the same date, October 24th, right? I am sorry, what time? The last text was at 7:24 p.m.? Correct. So that whole exchange was between 7:10 and 7:24 p.m.? Correct. That was an exchange because you had been receiving a bunch of harassing phone calls the prior 3 days? Correct. Do you recall at 7:48 texting Keith Schiller about this 14-year-old? Do you recall that? Do you recall that? I don't recall. Do you recall texting Keith Schiller about 7:48 p.m.? Who can I speak to regarding harassing calls to myself in office? And don't forget to block his number on one of them. And the dope forgot to block his number on one of them. You don't recall that? It sounds right. Yes, sir. Let's take a look if we can show the witness B266. This is a series of texts between you and Mr. Schiller on that same date. You said, who can I speak to regarding harassing calls to my cell in office? The dope forgot to block his call on one of them. Do you see that? I see it. Mr. Schiller says, objection, reading a document not in evidence. Sustained. Do you recall at 8:02 your initial text to Mr. Schiller is at 7:48, and then at 8:02 he says, call me to your right? To you, right? Yes, sir. So if we were to put that up already, it's already into evidence. These are the phone calls between you and Mr. Schiller, right? Do you see? That's fine. Yes, sir. And then at 8:02, he says, call me. And then it looks like you then call him at 8:02 for 1 minute and 36 seconds, right? Correct. And if you look at that call me text, if we can take that down for a second and put up B166, you will agree with me that Mr. Schiller told you to call him at 8:02 and 21 seconds, right? Yes, sir. And so you called him back. And if we can go back to that phone record, you called him back at 8:02. It's likely after 8:02 and 21 seconds, right? That's correct. This is the call that you testified about on Tuesday, that you had a conversation with President Trump, that you called Keith Schiller. It wasn't to talk to Keith Schiller. It was to talk to President Trump about the Stormy deal and moving forward. That was your testimony. Yes, sir. Let's look at what happened next. Let's go back to B166 at 8:04. You text Mr. Schiller the number. I am going to object to the reading of the document. That's not in evidence. That's not in evidence. Your Honor, I will offer B166 in evidence. Any objection? I think he just needs to lay a foundation. You see the text that you're looking at, B166, between you and Mr. Schiller. You can look at the first page too. See, it says Cellbrite. It has your number, Mr. Schiller's number. Yes. We offer B166 with redactions. If you can make the necessary redactions, we'll redact, of course, absolutely. For now, it can just be shown to the jury, not in the courtroom. I don't know if you can do that. We were told that we can. It's being shown to the jury, but not everybody else in the court. Let's look at it with the jury. Just to go back to that conversation between you and Keith. Who can I speak to regarding phone calls to my cell and office? The dope forgot to block one of them. That was at 7:48. At 8:02, he said, call me. I can put it back up again. At 8:01, is when he leaves that voicemail. Yes. You call him back at 8:02 for 1 minute and 36 seconds. At 8:04, you text him that number of the 14-year-old who was prank calling you, correct? I did, yes. Immediately, he texts you back. Within a few seconds, he says, okay. Yes, sir. The very next morning at 7:58 a.m., you say, did you reach the family, right? Yes, sir. Let's take that down. When you testified on Tuesday that you had specific recollection of that 1 minute and 36 phone call on October 24th was not with Keith Schiller, that you called Keith Schiller and he passed the phone to President Trump. You finished the deal with Stormy Daniels and you said, we're going to move forward. And he said, yes, because you kept him informed at all times. That was your testimony, right? That's correct. That was a lie. You actually were talking to Mr. Schiller about the fact that you were getting harassing phone calls from a 14-year-old, correct? Part of it was the 14-year-old, but I know that Keith was with Mr. Trump at the time, and there was more than potentially just this. That's what I recall based upon the documents that I reviewed. 5 minutes ago, I asked you if you remember harassing phone calls, and you said no. And then I refreshed your recollection. It's totally fair if you don't remember. But now your testimony is that you were testifying truthfully on Tuesday to a 1 minute and 30-second phone call, and you had enough time in that 1 minute and 36 seconds to update Mr. Schiller about all the problems you were having with these harassing phone calls, and also update President Trump on the status of the Stormy Daniels situation, because you had to keep him informed, because every time you made a decision, you ran it by the boss. That's your testimony. I always ran everything by the boss immediately. And in this case, it could have just been saying everything is being taken care of. It's going to get resolved. That's not what you testified to on Tuesday. You said you had a recollection of a phone call on October 24th at 8:02 p.m. where you called Mr. Schiller and he gave the phone to President Trump, and you told President Trump about the updates, that you were moving forward with the funding, and he said, okay, go. That was a lie. You did not talk to President Trump on that night. You talked to Keith Schiller about what we just went through. You can't admit it? No, sir, I can't. I'm not certain that is accurate. You were certain it was accurate on Tuesday when you were under oath and testifying. You were certain it was accurate. You had a phone call to President Trump, but now you're saying you're not certain it was accurate? Based upon the records that I was able to review in light of everything that was going on, I believe I also spoke to President Trump and told him everything regarding the Stormy Daniels matter was being worked on and it's going to be resolved. We're not asking for your belief. This jury doesn't want to hear what you think happened. Objection. Sustained. I want to put up People's Exhibit 262. It's in evidence. Sir, you may recall that the people showed you this exhibit and you testified that these were certain text messages between you and Mr. Schiller in spans March 4th of 2016 to November 4th of 2016. Do you see the exhibit? I am sorry. One more time, the dates. The dates, I believe, is from March 4th of 2016 to November 4th of 2016. Yes, sir. You were shown all of those texts by the prosecution, correct? By the prosecution, correct. If we can focus in on the October timeframe on this exhibit, did the people include the text messages I just showed you between you and Keith Will Schiller on October 24th of this exhibit? Yes, sir. You see those text messages on the exhibit? I don't. The people did not bother to include those on this chart, did they? Not on this chart, no, sir. When they prepped you and they showed you this chart, right? They prepped you and they showed you this chart. You didn't see this chart for the first time on Tuesday, did you? Objection. Sustained. When they prepped you, did they show you a chart? Objection. Sustained. Were you ever shown in prep the text that I just showed you between you and Mr. Schiller about the harassing phone calls? Objection. Overruled. No, sir. The first time you had been shown those texts in 7 or 8 years was just a few minutes ago. Yes. Given that your testimony to this jury is still when you testified on Tuesday that you have a specific recollection of a phone call with President Trump on October 24th at 8:02 for 1 minute and 36 seconds, that you were telling the truth. Based upon what was going on and based upon the other text messages and so on regarding the Stormy Daniels matter, yes, I believe I was telling the truth. So you are not basing your testimony on Tuesday based upon your memory, but basing it upon documents that the people showed you in prep. Is that your testimony? That refreshed my memory. Yes, sir. Was that true for just the phone calls, or was it true for other phone calls too? I don't recall telephone calls on a specific date going back to 2016, based upon the records and based upon the documents that you were reviewing. Mr. Cohen, you just said you don't recall phone calls back in 2016. That is not what you testified to on Tuesday. On Tuesday, you testified that you remember the phone call. Objection. Sustained. Is now a good time for a break? Jurors, let's go ahead and take our lunch and recess. All right, everybody, so I will break here for this particular piece of Mr. Cohen's cross-examination. So I wanted to take you through that back and forth that happened with Mr. Blanche. So in order to give you the context for when we go into our redirect, everyone. So we will now move into the redirect. So once Mr. Blanche finished his cross-examination, which was really more of the same, then the state had a chance to go back and do what we call a redirect. And so she went in and kind of clarified some things. So now we are going to be hearing from the state for Mr. Cohen, and this will be her redirect. So let me walk you through that. Again, she's in blue as the state of New York. Good afternoon, Mr. Cohen. Good afternoon. I just want to ask you some follow-up questions based on defense counsel's questions. Now, defense counsel asked you a question and it was rather fast, but I want to ask it a little bit more slowly. He asked whether you testified falsely in Congress in 2019. Did you testify truthfully in Congress in 2019? Yes, ma'am. Was it in Congress in 2017 that you testified falsely? Yes, ma'am. That's what I thought he said. Was it just a mistake that when you said yes when he asked you about 2019? Yes, ma'am. Now, defense counsel asked you if you may have discussed other matters on telephone calls in the morning of October 26th of 2016 with President Trump, meaning other matters besides the Stormy Daniels matter. Do you remember that question? I do. And you testified that you didn't have a specific recollection about talking about other matters. Was that right? Correct. But you did have a specific recollection about talking about Stormy Daniels' payoff to Mr. Trump. Yes, ma'am. And that is because it was important to you at that time, correct? Yes, ma'am. So is it possible that other matters may have been discussed on those phone calls, but you are sure that the Stormy Daniels matter was discussed? Yes. Objection. Overruled. Now, defense counsel asked you a lot of questions about how busy you were in October of 2016. Do you remember that? Yes, sir, ma'am. Were you pretty busy all the time or just in October of 2016? I was busy. Were you too busy in October of 2016 to finalize the Stormy Daniels' payoff with Mr. Trump? No, ma'am. Were you too busy to get his approval to make that payoff? No, ma'am. Now, Mr. Blanche asked you about an email from Mr. Wesselberg, People's 260 in evidence. It was an email in January of 2016. Mr. Wesselberg asked you to send in the agreement we're discussing. Do you remember those questions? I do. Did you ever send Mr. Wesselberg a retainer agreement? No, ma'am. Why not? Because it was no legal work that I was to be paid for. There was no representation agreement within which to send. And was that $420,000 payment that you were owed as reimbursement, did that have anything to do with a retainer agreement? No, ma'am. And so ultimately, did Mr. Wesselberg just ask you to send invoices instead of for the reimbursement payments? Yes, yes. Now, both on direct examination when I asked you and also on cross-examination when Mr. Blanche asked you, he asked you about legal work that you did and other work that you did for Mr. Trump and his family in 2017. Do you remember those questions? I do. And you said you did some of the work for Mr. Trump in that year, right? Correct. And you did some of that work for his wife in that year? Yes, ma'am. And did you ever bill for that work? No, ma'am. And did the $420,000 reimbursement payments have anything to do with that work that you did? No. And in 2018, I asked you some questions about that as well. Did you do some work in 2018 for Mr. Trump? I did. Did you ever bill for that work? No, ma'am. By the way, did you ever get paid a dime for the work in 2018? No, ma'am. Now, Mr. Blanche asked you about the consulting agreements in 2017 and 2018 and other work that you did for other people. Did you ever tell Mr. Trump that you were only going to do work for him and never do any work for anybody else? Objection. Overruled. You can answer. No. There was no such understanding, was there? No, ma'am. Now, Mr. Blanche asked you some questions about Red Finch. Do you remember the questions about the $50,000 owed to Red Finch? I do. Can you tell the jury exactly what the work was that Red Finch did for Mr. Trump? Red Finch is a technology company that I had asked to assist in a CNBC poll, and the poll was regarding the most famous businessmen in the last century. Mr. Trump's name was on the list, and at the beginning of the poll, he was polling towards the very, very bottom, and it upset him. And so he had come to me, to his office, and provided me with a sheet of paper that showed it. I reached out to the gentleman from Red Finch who assured me that he was able to, through the acquisition of an IP address, to create an algorithm that would ensure that Mr. Trump would rise and rise significantly into this poll. And so I had expressed what I had learned, and we talked about what number Mr. Trump wanted to finish. Of course, initially he wanted to be number 1, but we didn't think that that was a good idea because it would be, of course, it would raise red flags. As long as we were in the top 10, we would go into another round. And so with Mr. Trump's permission, I advised the president, CEO of Red Finch, to start acquiring the IP addresses, and more IP addresses were needed because the volume was actually greater than what we all anticipated. And so we had to purchase more IP addresses and then even more again until ultimately, when the poll came to its conclusion, Mr. Trump was number 9. And just as a reminder, did Mr. Trump say that he wouldn't pay Red Finch for the work that they had done to make sure that his name was higher in the polls? Yes. Did he say why he wouldn't pay them? He did. What was it? Because CNBC ended up not continuing and moving forward with this poll, and he didn't feel that he had gotten the benefit of what the services were supposed to ultimately provide. And that, of course, was being number 9. CNBC had the right to some language, and they can take anybody out of the poll that they wanted to, and Mr. Trump didn't feel he got the benefit of what the funds were supposed to do, what the funds were supposed to go to, despite achieving number 9, and refused to make the payment. So, Mr. Cohen, after some period of time, you felt pressure to make some payment to your friend, to your colleague? Yes. And that's after the bills had been outstanding for some period? For some period. Now, Mr. Blanche did ask you also about the extra $30,000 that you got from the Trump Organization for Red Finch. You paid your friend 20, but you took the 30. Why did you take that extra 30? Why didn't you just put 20 on the list instead of 50? For a long time, I'd been telling them about the $50,000, so I could have collected it for Mr. Trump or Red Finch. I was angered because of the reduction in the bonus, so I just felt it was almost like self-help. You know, I wasn't going to let him have the benefit this way as well. I wasn't going to correct the conversation I was having with Alan about it. I had not only protected him to the best that I could, but I had also laid out money to Red Finch like a year and a half earlier. And again, $130,000 to have my bonus cut in 2/3 was very upsetting, to say the least. But you admitted on cross-examination that it was wrongful? It was. Now, defense counsel asked you last week some questions about the letter that your attorney, Stephen Ryan, wrote for you in February of 2018 and submitted to the FEC in response to that complaint. Do you remember? I do. Let's put up People's Exhibit 201, please. Defense counsel showed you this letter. Do you remember that? Yes, ma'am. He highlighted the second paragraph and read that to you. Do you remember that? I do. When he asked you about it, you said it was an omission. Correct. When I asked you about it on direct examination, you said it was also misleading and deceptive. Yes, ma'am. Can you explain to the jury why it was misleading and deceptive? Well, the misleading deceptive line is neither the Trump organization nor the Trump campaign was a party to the transaction with Ms. Clifford, and neither reimbursed Mr. Cohen for the payments directly or indirectly. So what is omitted from the paragraph that makes it deceptive? The fact that it was getting paid for by Mr. Trump or the Trump Trust. Did you intend for it to be misleading in that way? I did. Can we take a look at paragraph 3 now? The payment in question does not constitute a campaign contribution or expenditure. Do you see that line? I do. When defense counsel was reading that line to you, you said correct. Let me ask you the question. Is it a truthful sentence? Objection. Please approach. Everybody, I'll take a moment and just say I do have my colors off here just a little bit. These should be set out in a little bit different way, but we'll just go forward from there. OCD is getting me at the moment. So here we go. Miss Hoffinger, again, this is her redirect. So Mr. Blanche is looking at the transcript. Mr. Blanche read up through that line and he said correct, which I think left a misleading impression, which is that he was saying that the sentence was correct, and I'm asking him if it was a truthful statement. Judge, we're not allowing an expert to talk about what's a truthful statement. He's certainly not going to be able to say whether it was a truthful question. That was the question. That is not the question that I asked. Take a look at the transcript exactly. It was a series of questions about what was truthful. The entire letter at the time was his testimony was everything was truthful. Now the people, you asked him, was it truthful? The whole letter, that section of the letter, and asked him, was the part truthful? Was this part truthful? He is the witness talking about whether it's not truthful. You asked the question. You asked him the question. Before this question is answered, we should look at the transcripts. Look at it. Page 3570, I have the wrong one. I apologize. It's 3963. Okay. You just said correct. 3963. I have it right here. Show it to me. It's a small version. It's a little hard to read without my glasses if you read that line. Is that correct? I wasn't asking if it was truthful. I was asking if the letter said it. That's why then he said a few seconds later, is everything that you said in the letter true? It left a misimpression. 3963. But that is the true statement, right? Answer, that's the true statement. Question, meaning you use your own funds to make the payments to Ms. Daniels. Answer, correct. Question, and neither the Trump organization nor the campaign paid you back, right? Answer, it was a party to the transaction or not. I'm looking for the part where he asked whether it was a campaign contribution. Do you have that? Line 17 on 3963, question, and that it doesn't constitute a campaign contribution or expenditure, and therefore the FEC lacks jurisdiction over the matter. What page is that? 3963. 3963. If you want to look at it, I could hand it up to you. It's underlined there, 3963, line 17. I'm asking if it's true. On 3963, beginning on line 17. and that it doesn't constitute a campaign contribution or expenditure, and therefore the FEC lacks jurisdiction over the matter. Answer: correct. I was reading that it's correct. That's what the letter says. Exactly. The people will have an opportunity to clean that up. Thank you. I thought you made your ruling, which is why I left. Depending on the answer, we would ask for an instruction again. I'm not sure how the witness is going to answer the question. What is your proposed instruction? If he says that it's not true that he did commit a campaign violation, we would ask for the instruction that we asked for repeatedly, that you gave, the fact that he said that he committed a campaign violation. Is it your understanding at this point whether that's a false statement in the letter? That's why I'm asking. That's why we want the clarification. Okay, thank you. The court's version is on page 3964, whereupon the following was in open court. So now we are back into our redirect again, everyone. All right? So stay with me here. Can we get back up the letter again? People's Exhibit 201. And the line in paragraph 3 that says the payment in question does not constitute a campaign contribution. Do you see that line, Mr. Cohen? I do. Let me ask you, was that a true statement? No, ma'am. Are you asking for an instruction? Yes. All right. Jurors, you just heard the questions that were asked of Mr. Cohen in his response, that it was not a true statement. Put it back up. It was the third paragraph, that the payment in question does not constitute a campaign contribution or expenditure, and Mr. Cohen responded that is not true. I remind you that Michael Cohen pleaded guilty to violating the Federal Election Campaign Act, but that evidence has been permitted to assist you in assessing Mr. Cohen's credibility as a witness and to help provide context for some of the other evidence that has been offered. You may consider that testimony for those purposes only. Mr. Cohen's plea is not evidence of the defendant's guilt. You may not consider it in determining whether the defendant is guilty or not guilty of the charged crimes. Thank you. Can we now put up People's 202? Do you recall, Mr. Cohen, the defense counsel asked you some additional questions about this document? Yes. Is this a statement regarding the FEC matter that you released to the press? Yes. Now, defense counsel asked you about one line in that letter. Just because something isn't true doesn't mean it can't cause you damage. I will always protect Mr. Trump. Do you remember that question about that line? Yes. Do you remember your answer of why you included that line and you said you wanted reporters to believe that it was true? Yes. Now, in general, was that statement that you issued to the press overall, was it false or misleading? Yes. Why was that? Again, it goes back to the part about neither the Trump organization nor Trump campaign was a party to the transaction with Ms. Clifford, and neither reimbursed me for the payment, either directly or indirectly. So what was misleading? Who made the payments? That either the Trump Trust or Mr. Trump himself. And did you intend it to be misleading in that way? Yes, ma'am. Can we please put up the line at the end of the second paragraph? The payment to Ms. Clifford was lawful and not a campaign contribution or campaign expenditure by anyone. Do you see that line? Yes. Was that truthful? No, ma'am. Objection. Overruled. Did Mr. Trump approve the substance of the false statements by you? Yes, ma'am. And in fact, had you provided the substance of this to Jay Sekulow, Mr. Trump's attorney? I did. Can we take that down and put up People's 216? What was your understanding of what that was about? It was about the sum and substance of the response that I just read. Now, defense counsel asked you some questions about whether NDAs or settlement agreements happen all the time. Do you remember those questions? I do. And he asked you whether in normal situation an NDA was perfectly legal. Do you remember that? Yes, I do. You said it was? I do. Do you remember that? I do. Were the circumstances surrounding this NDA and you paying Stormy Daniels at Mr. Trump's direction and for the principal purposes of his election, was that perfectly legal? Objection. Sustained to leading. Please rephrase. Was the circumstances of this NDA that you testified to, was that perfectly legal? Objection. Overruled. I couldn't hear your answer. Can you repeat it? Under the circumstances of this NDA with Stormy Daniels that you testified to, was it perfectly legal under those circumstances? No, ma'am. On August 21st of 2018, did you plead guilty to making an excessive campaign contribution in violation of the Federal Election Campaign Act in connection with that payoff to Stormy Daniels? Objection. Overruled. I did. On Tuesday, I believe defense counsel read to you what you said at the hearing about the crimes of tax evasion and false statements to a bank. Do you remember that? I do. And he asked you what you said with respect to those charges. Do you remember? Yes. Did he ask you what you said under oath about making excessive campaign contributions and violations of the FECA when you paid off Stormy Daniels? Objection. May we approach? Judge, they can't pick and choose which portion of the allocution to read at 3801 and 3802. Go through the sections that he pointed out. He specifically read to the witness his allocution of August 21st of 2018 and had him say yes, that was what he allocated to with respect to the counts of tax evasion and the count of false statements to the bank. But he did not read the allocution with respect to the payoffs to Stormy Daniels and the payoff to Karen McDougal as being illegal campaign contributions. He read that allocution. I think at this point we're entitled to read the allocutions. Absolutely not. The reason why those were read is because he later said that he was lying under oath when he made those statements. That's why we elicited that statement. That's perfectly legal and proper to elicit specific incidents where the individual has lied under oath. The only reason why I elicited those statements from him is that the witness later on, again in this courtroom, said that those were lies under oath. He was saying he didn't commit the crime. I wasn't picking and choosing which part of the allocution to read into the record, just the part of the allocution where he specifically said he lied. That's completely different than just letting them blast out that he pled guilty. It's very, very prejudicial to allow it, so I'm going to side with the defense. Okay, may we approach for a minute? For the record, the objection is sustained. I just need clarification of your decision. I could still ask him when he pled guilty to those two counts what was true then and what is true now. I'm not reading the allocution. I could still do that given that the questions that was just asked on the score, on that score, I think I should be able to. I'm not going to read the allocution. Look, arguably that would be fine, but I think it came out a couple of times in an excess of caution. It's better to stay away from it. Okay, back to the redirect. Now, defense counsel asked you last week, and I think today as well, about whether the outcome of this trial affects you personally. Do you remember those questions? I do. There were questions about your plea back in 2018 and how it affected you personally. Do you remember those questions? Yes. Now, I know it may feel like you are on trial here after cross-examination. Are you actually on trial here? Objection. Overruled. Are you actually on trial here in this case? No, ma'am. Are you a witness here? Yes. Are you charged with any crime in this case? No, ma'am. Is your liberty at stake in this case? No, ma'am. Is your wife's liberty at stake in this case? No, ma'am. Did we subpoena you to testify here? Yes, ma'am. So is that different? Is this situation different from the situation you were in 2018 with the criminal charges brought against you? Yes. You want to explain the difference? The other one, it was my life was on the line, my liberty. I was the defendant in that case. Again, here, I'm just a non-party subpoenaed witness. And was there an issue about whether your wife might be charged in that case? Yes, ma'am. Now, one moment, please. I want to clarify something. When you left the Trump Organization to become a personal attorney to the president, withdrawn, you were asked questions about whether you would have a retainer agreement when you worked for a company. What's your understanding when a lawyer works for a company about whether one has to have a retainer agreement? You're an employee, it's unnecessary. To clarify, when you left the Trump Organization, you were no longer an employee, but private counsel when you left in 2017. That's correct. Did you ever put together a retainer agreement for any of the work that you did for President Trump? No, ma'am. Why was that? I never expected to get paid. And did you ever bill for any services or work that you did for President Trump in 2017 or 2018? No, ma'am. Did the $420,000 that you received in 2017 have anything to do with legal services you provided in 2017? No. And when you submitted each of your 11 invoices to the Trump Organization stating that each was for services rendered for the month in question pursuant to a retainer agreement. Was that true or false? It was false. And when you received those 11 checks from the revocable trust and from Donald Trump in response to those false invoices, was the stub and the stub attached to those checks which said retainer for the particular month, was that true or false? It was false. Now, you were asked some questions about Mr. Costello. Do you remember that? Yes, ma'am. Did you ever sign a retainer agreement with him? No, ma'am. Why not? I didn't trust him. I didn't like the way that he kept invoking Rudy Giuliani, and my concern was that anything that I would say to him would immediately go directly back to President Trump. And did you ever agree to pay him anything? No, ma'am. Is that why you didn't sign the retainer agreement also? Yes. Now, in February of 2019, did you speak to some prosecutors at the Southern District about Mr. Costello? Yes. Did they have some questions for you about him? They did. And in order to answer those questions, did you sign a waiver agreement with respect to Mr. Costello so you could answer those questions? Yes, ma'am. Can we please put those up for the witness? Do you recognize that document, Mr. Cohen? I do. What is it? This is a waiver document. Did you sign it? I did. Who did you provide it to? To your office. Understood. But prior to our office in 2019, do you know who? The Southern District of New York. Is that an exact copy of the waiver agreement? Is it signed by you? Yes, ma'am. I offer that into evidence. No objection. It's accepted into evidence. Tea break, everybody. Can we read that for the jury? First paragraph and then the second paragraph. I, Michael D. Cohen, hereby declare, 1, I am a defendant in the above captioned case. Number 2, I was previously represented by the law firm of McDermott, Will, and Emery in connection with the investigation that preceded this case, the SDNY investigation, as well as in connection with the investigations into alleged Russian influence and the 2016 presidential election. During the period in which I was represented by MWE, I was approached by Robert Costello, Esquire, of the law firm of Davidoff, Hutcher, and Citron, LLC. Costello sought to represent me in connection with the SDNY investigation and presented me with a retainer agreement. I declined to sign the retainer agreement and informed him I was already represented. Although I subsequently had several other conversations and communications with Costello, at no time did I sign a retainer or otherwise agree to retain Costello, nor did I ever consider Costello or any lawyer at the DHC to be my attorney. Although I do not believe that any of my communications with Costello or other lawyers at DHC are subject to attorney-client privilege, I hereby waive whatever attorney-client or other privilege that might be argued. I have attached such communications. You can take that down. There was a last line there. I apologize. I have discussed the foregoing with my current counsel and am making this waiver knowingly and voluntarily. Signed February 7th of 2019. So you waived any privilege that you might have with respect to the communications with Mr. Costello so you could answer questions. Is that right? That's correct. You are able to answer questions here because you waived any privilege. Is that right? That's correct. Now, defense counsel asked you some questions last week about what some of your texts with people, texts with Keith Schiller, texts with other people that you know. You were asked today about some texts. They asked you some questions about phone calls, emails, and conversations that you taped with various individuals. Do you remember all those questions? I do. And in January of 2023, when you surrendered your phones to our office voluntarily, did you understand that we would copy everything on those phones and turn over a copy of all that material to defense counsel? Yes, I was advised. You were aware that we did turn over all of that material to defense counsel? Yes, ma'am. Now, last week, Mr. Blanche asked you some questions about your lawyer submitting an application in November of 2023 to a federal judge for early termination of your supervised release. Do you remember those questions? I do. And he asked you about your role in your lawyer's submission for some legal cases that turned out to be fake or not real cases. Do you remember those questions? I do. And you explained some of what occurred to Mr. Blanche. Can you explain a little bit more about what happened? Did you intend to mislead anybody about those Google Bard searches and providing those cases to your lawyer? No. Can you explain a little bit more about what happened? Again, I went on to Google Bard, which is an AI search engine. I typed in a query, Second Department of New York cases regarding early termination of supervised release based upon certain factors. And it gave me a plethora of cases that appeared to me to be legitimate. They certainly look legitimate. There were facts behind it and supported what we were going to put into the upcoming motion. And so after I copied and pasted the first three, because they were on point, I sent them over to my lawyer's office to review and incorporate into the document. I was just trying to be helpful. I didn't have any longer, whether it was Westlaw or LexisNexis, anticipating they would look it over just to make sure that the information was accurate and correct and fit into the motion that was being put forth on my behalf. I ultimately also sent in my current lawyer, Dania Perry, and she noticed that these cases were not legitimate. They were all created by the AI program, which wants to please the user, so it created these hypotheticals. And Miss Perry immediately notified me that they're wrong and that we should notify the court, to which I sent her, absolutely, please do. At which point, Miss Perry went ahead and sent the letter to the judge advising him that these three cases, the citations were inaccurate, and that Miss Perry even went so far as to find the three cases that were directly on point, just different names, different citations, but with the same underlying facts. So your lawyer notified the court that the cases were not correct? Yes, I authorized her to do that when she advised me the citations were inaccurate. Now, you were questioned by defense counsel regarding sorry everyone, I've got a puzzle piece. One moment, please. I have to verify I'm doing a live right now. Oh, all right, and we're back. All right, so yes, I authorized her to do that. She advised me that the citations were inaccurate. Now, you were questioned by defense counsel regarding a call at 8:02 p.m. with Keith Schiller and Mr. Trump on October 24th of 2016. Do you remember those questions? I do. Can we put that up just for the witness? Do you recognize anyone in the People's Exhibit 417B for identification? I do. Who do you recognize in that picture? I recognize President Trump, who is off to the right, and in the dead center, Keith Schiller. What is Keith Schiller wearing in the picture? He's wearing a dark suit with a white shirt and a red tie. Your Honor, we offer that into evidence. Objection. Please approach. All right, so here's the sidebar regarding the CNN picture, everyone, or the C-SPAN picture. Your Honor, this is a picture, I believe, of a rally on that same day in Tampa, Florida. Now, there's a date on there somewhere, I presume, and it says the date. That's inadmissible hearsay. There is no way this witness can say that this picture is from a rally on that date. It's a complete violation of laws. I tell you what I'm going to do. I skipped a step. I'm going to offer one more picture, which is going to also show, again, President Trump there on that date, and ask if it's true and accurate representation of how Mr. Schiller and Mr. Trump looked in October of 2016. If you wish, we can offer it subject to connection. We have an additional witness who will testify. What? We have an additional witness who will testify how these screenshots from the video of a rally were obtained. We can do that. It would be subject to connection. If it's just for the purpose of identifying the additional witness is a paralegal who's going to say they Googled it. It's massive hearsay. You cannot admit into evidence for the truth of the photograph of a specific date based upon a paralegal Googling it. He reviewed the audio tape. The tape was from C-SPAN. There's testimony how it's retrieved and how he reviewed the rally. These were screenshots. Let's take our lunch recess and we can discuss this on the record. Thank you, Your Honor. Whereupon the following was in. Jurors, I remind you, all of you, of all of my instructions, including do not discuss this case either amongst yourselves or with others. I'll see you at 2:15. Enjoy your lunch. So we have a lunch break, and this is where we're going to get into the back and forth between this photograph that is explaining that phone call texting situation. All right, here we go. I thought it would be easier to excuse the jury and discuss this out of the presence of the jury. I'm going to let Mr. Steinglass speak. So, what the proffered exhibits are, 417A and B, are photos of the defendant together with Keith Schiller that were taken on October 24th at about 7:57 p.m., which shows that they are together. That is the response to any potential defense, a suggestion that there may be the call that took place on that night, October 24th, between Mr. Cohen and Keith Schiller, that the defense should not be able to argue that Mr. Trump was not there and did not participate in the conversation or subsequent conversation during that same call. So I believe it takes three things to get this photo in. One is that the witness has to identify the parties, which the witness has done. Two, we have to be able to establish how this was pulled from C-SPAN's archives from their website, which we have a paralegal lined up to do. And third piece comes from C-SPAN themselves when they testified earlier in this trial that the way that they archive and produce case materials, which is enough to lay the proper foundation to admit the photos, which proves that the defendant and Mr. Schiller were together at the time of the call on October 24th. So you're offering it to establish the date and time? Yes. Do you have a copy? Sure. Yes, Mr. Blanche. Your Honor, we never asked or implied that Mr. Schiller was or was not with President Trump on that day. What we argued and implied is that the phone call that was made to Keith Schiller about the completely different topic that was what the witness testified to on direct. So the first point here is we somehow implied that President Trump and Mr. Schiller were not together. That was not our position at all. It's not going to be our position. Secondly, and most significantly, both of these have the same hearsay problems that we argued, and Your Honor didn't go with us, that the tweets have. There is going to be a witness, apparently, that's going to testify that the only thing that matters about this entire exhibit is the date and time. Okay, that's inadmissible hearsay. It's a business record. And there was a C-SPAN witness, and the C-SPAN witness could potentially authenticate the documents. We don't know. They weren't supplied the documents. There was a ton of foundation laid about the exhibits that were shown and established. Indeed, the rally took place that day, and they were perfectly comfortable asking a dozen questions or so to lay a proper business foundation. And so now they say, well, we laid the proper business foundation for the exhibits that were offered a few weeks ago. We don't want to do that again. We're going to have a paralegal come in and say they Googled it. That's an exception to the hearsay rule. That's not the rules. Didn't the witness come from C-SPAN lay the foundation? Didn't the witnesses testify to the functions and how they maintained the records and the liability? And how long they were doing it? Didn't he lay a foundation for how they were maintained? Absolutely. They were kept in the archives. When he got the subpoena, he went into the archives and pulled the documents and confirmed they were accurate, which is what the rules require. It seems like it's neither here nor there. We all have Googled. The rules of evidence have to apply. You still have to establish a foundation that isn't met here, especially when one of these pictures is not a picture of Mr. Schiller. One of them is, and the one that is, again, the only relevance at all about any of this, again, is the date and the time. And so it's an out-of-court statement being offered for the truth of the matter asserted, just like we said before, but it's even more poignant here. It's inadmissible. Well, so there are a few points I'd like to make. First of all, I think if you go back and look at the C-SPAN testimony, which is on page 1665 through 1667, there's a whole lot of detail about how the camera operator reports the events in real time. And the camera operator has a business duty to do so accurately. They try to record the entire event. They watch it from end to end to make sure there's no interruption when it airs. This was not pulled off of Google. This was pulled off of C-SPAN's website. I believe we can satisfy the foundation requirements. It seems like Mr. Blanche is also making a kind of relevance argument and saying that it's irrelevant to their argument that Mr. Trump was together with Mr. Schiller at the time. And not just together, but that the speech ended at 7:57, that the defendant was giving that night. They walked off the stage together at 7:57. That is not how the defense is getting at. It's certainly an implication that was raised by defense's questions. Who knows what they're going to say in their summation. We're entitled to establish. I realize this is not wholly responsive to what happened to their arguments. What happened in the phone call, it's certainly particularly responsive for us to be able to prove that the defendant and Mr. Schiller were together at the time of this phone call. And I think that relevancy is a low threshold. So I think there's more probative value to that. There is no prejudice. We can lay the proper foundation. That's all we have to do. I was not making this argument. I was responding to the people's suggestion. When we asked Mr. Cohen, we implied that he wasn't with Mr. Schiller. There's no evidence of that. I have significant evidence that he lied under oath when he said he had a conversation with Mr. Trump that night. And that is what I crossed him on. That is the issue. Now, it's not a relevance argument. It's an absolutely inadmissible hearsay argument. If Your Honor looks at the testimony from the C-SPAN witnesses, including through page 16, 68, and 69, there were multiple questions to this witness about how careful the process is to authenticating something that they record. That's for good reason. The rules require it. It's not that they require it for one rally video. It doesn't count for only this one in Tampa. It's the rules require it. It's not inadmissible. I'm sorry. I didn't follow that. He was very careful and he testified in great detail. Why are you saying that that testimony does not apply to this rally? Well, it applies to the process that he went through in responding to the subpoena to confirm that this record that this jury is going to see is a true and accurate business record of C-SPAN, not of C-SPAN's website as taken by a paralegal. There's a difference. Give me an offer of proof as to what the paralegal would testify to. Essentially, the paralegal will testify to that they were on an official website of C-SPAN, that they know how C-SPAN stores its videos, and that this is based part on the familiarity with this case, but also on the testimony of Dr. Browning that they were present for, and they will testify that they were able to retrieve this exhibit and that the exhibit on its face shows it's a first run, and it started at a particular time and it ended at a particular time. The C-SPAN representative testified that the videos are aired in their entirety. I mean, to me, to the extent that this is not a tight foundation, I think it's pretty tight foundation. But if the two additional questions would be necessary, we can fly the C-SPAN representative back here to answer these questions. But I think that as the record exists now from the C-SPAN witness, it's perfectly sufficient. What would the two questions that you would ask the C-SPAN representative be? I don't think we need to ask any of the C-SPAN rep. If Mr. Blanche believes the foundation is somehow insufficient based on everything that the C-SPAN rep already testified to, and one or two questions would have to be asked in regard to the particular video, I think we can do that. I believe that's an exercise in futility. Let me ask Mr. Blanche, why is the foundation that was laid by the C-SPAN representative, Dr. Browning, why is that foundation not good enough for this document? There was no foundation laid for this document. Judge, whenever a witness who testifies as an exception to a hearsay rule, then that something is a business record, just because they establish the foundation that a particular document from an organization, or in this case, a rally video is a business record, doesn't mean that whatever else that the company produced or whatever else we pull off the internet, we can go and borrow those foundational questions. I would say that probably applies to the video as well. It's not the way the rules of evidence work. By the way, I'm sure that the people know about this issue. We certainly did before today. And so they should have brought this witness back. I mean, it cannot be that there's hearsay exception that applies that can be easily be cured and that the people will say we tried once and we're not able to try it again. Try it this time. What are the pages of Mr. Browning's testimony? It's Dr. Browning. Dr. Browning, I'm sorry. I'm not sure of the pagination on the small version is exactly as Your Honor. It's approximately page 1665. All of his testimony starts on page 1660 and goes to 1670. I'm not concerned. I think it's relevant. I want to look into the hearsay issues. We will discuss it after lunch. Enjoy your lunch. There we are on a lunch break, everyone. All right, so at this point, I am going to go ahead and read through the judge's ruling and how we get to an answer on this. I am going to skip through a couple of sections through the judge's ruling, and then I'll go ahead and turn on a Q&A at this point. But I think it's important to see how the judge rules in here. Okay, before you went to lunch, we had a discussion regarding the people's proposal to introduce into evidence 2 videos, or at least stills taken from videos the defense objected. Over lunch, I did receive the people's submission, just section 9.14 to the rules of evidence. Also, People v. Goldman, that's a Court of Appeals decision. I had an opportunity to read through the testimony of Dr. Browning. I wanted to see exactly what he had testified to and what kind of foundation he made. I was able to do so. So beginning on page 1664, I will be jumping around a little bit. Now, the judge goes through and reads through the transcript of the testimony. I'm not going to reread through that, everyone. I will skip ahead a little bit because it is quite a bit. He's going back through to explain his ruling here. So let's just get to the ruling. And we have multiple pages going back and forth. So once he finishes quoting the testimony, the people offered into evidence exhibits 409A as in apple and 409D as in dog. First, I appreciate the case law that was referenced by the people during the lunch recess. I believe it's distinguishable from what we have going on right here now. I also do agree that certainly the proffered evidence is relevant. However, I don't see how the people can get past the hearsay objections. The testimony that was offered by Dr. Browning was foundation. One, he's highly qualified to give the foundation for the exhibits that we're going to be accepting, to whom those exhibits were going to be introduced. He didn't lay the general foundation for any and all videos. This goes for some videos that came through him. To suggest that the paralegal or anyone else can now take the stand based upon Dr. Browning's testimony states that they are now qualified to testify as a records custodian and authenticate the video would mean to suggest that whoever was here when Dr. Browning testified would be equally qualified to do the same. I don't think that we can do that. So the objection is sustained. Those images are not going to come in as offered. Anything else? And this is where things take a little bit of a turn, everybody. So the judge is saying, no, you cannot pull a paralegal in order to get this evidence in. So Mr. Steinglass from the state says, we accept your ruling, but I think that may mean that we want to bring in the C-SPAN rep back so that he could confirm the business record status of that video. So we're making arrangements to try to do that. Give me a time frame. We just reached out to them. We can update you at the end of today, the time frame. We asked them to be available as soon as possible. The court has the inherent authority to kind of control the order of proof that takes place in this trial. I don't think there's a reason this has to hold up the defense's case or any of the other witnesses that we have. I will just cite two quick cases on this point. The Hinckley case, which states the statutory order, as well as and the trial court maintains its common law discretionary power to alter the order of proof. So that's one site. This is pretty well established. I will give you a couple of quick sites. Court of Appeals, People v. Olson. I know I have the authority. I know it's discretionary. I will hear from the defense. We very much object. We're presumably within a few minutes of the people resting their case. We have witnesses here. There's a likelihood that we will rest today. So the people have known about this issue. Well, I don't know how long they've known about this issue, but certainly as of last Thursday, it was something that was elicited on cross-examination before lunch. So here we are on Monday, and they're about to rest, and they're asking, I guess, for an opportunity to see if this witness can come back. We very much object. We have a witness in the back that depending on how the rest of the cross goes, and assuming we call the witness, we have another short witness. We anticipate resting as well, at least as of now. We would object and ask the court not to allow the trial to just go on. People, why wasn't this taken care of sooner? Well, Judge, we learned about this over the weekend, and we've been making diligent efforts to move forward on this. Frankly, we thought that I understand Your Honor's ruling. I think it certainly was our position that the foundation was already set forth by Dr. Browning. It was sufficient to do this through this witness, though not only through three pieces I articulated before lunch. I don't want to characterize Your Honor's ruling. I understand it. I will certainly follow it. I think we have more than a good faith basis to believe it was going to come in. It didn't seem like Mr. Blanche is going to contest the fact that they were together. I am not sure why we're jumping through all of the hoops. I understand the rules of evidence apply. They have a right to put us through our burden. They don't have to stipulate, for example, that Mr. Schiller was together with Mr. Trump on that date and that time, although it does not sound like they're contesting that. That being said, we're doing our best we can to get this witness here as quickly as possible. Hopefully that will be tomorrow morning. All right. Are you objecting to letting the people finish out this witness and put on your case, and then we adjourn tomorrow morning and call this witness? Very much so. What is the prejudice? The prejudice is the sequence of events. The people rest, or we take witnesses out of turn just because we happen to have a witness here. To allow for the people to try to get a witness here by tomorrow morning to testify about something that there was testimony about last week, Your Honor, and I accept that this fact wasn't learned until over the weekend, but the call was made, apparently over lunch, to see if the witness can come out. This isn't a new fact. Presumably the people prepped Mr. Cohen on this phone call, and I don't. This is patently unfair in our view for the court to allow the people, given an obvious ruling of the admissibility of a picture on redirect, to allow them to stop, to presumably rest or not rest, make us decide what we want to put on, how we want to put our case on before they rested for no reason. I'm not going to make you put your case on before they rest. What I could do is simply adjourn until tomorrow. There have been multiple days where we've had to end early because the people are out of witnesses. There have been scheduling issues. That happens in trial. I don't contest that. Here we are now. Literally, the people are going to rest, and now they want more time to try to get a witness here tomorrow, and about something that was had on cross. That's not the way the trial is supposed to work, Judge. People, I would like you to take a minute and let me know if she can be here by 9:30 tomorrow. We've reached out and we're waiting to confirm. Let's recess and get back to me in a few minutes. Recess? People, what did you find out? Your Honor, we've been able to reach C-SPAN. They're booking travel flight right now in order to be available at 9:30 tomorrow morning. They stress that travel is not booked yet, but they are preparing to do that. Anything else, Mr. Blanche? No, just our continued objection. This will be the 5th and 6th time that we're going to apparently run out of witnesses for the day. We have witnesses here and ready to go, and we think the decision that Your Honor made that a witness has to come and testify that this shouldn't then be immediately compromised by giving the people more time to get that witness. That is wrong. We haven't broken early 5 or 6 days early. I can remember we broke a day early for a private medical matter that we shared with the court. That was just wrong. The testimony of this witness is so narrow that none of the proffered defense witnesses spoke to it. There's no particular reason why we couldn't keep going on. If Mr. Blanche wishes to do that, or if Your Honor has indicated a willingness to adjourn the case until tomorrow and let Mr. Blanche put on his case tomorrow, that's also fine. Essentially, the ball is in Mr. Blanche's court. I remember stopping early one time for medical reasons. Look, if scheduling were an issue of time were of the essence, I would agree with you, Mr. Blanche. We have agreed this morning that we're basically going to have a week down. We're sending the jury home for a week to do nothing. So there's no prejudice to anyone I can see whatsoever. Certainly, it's up to you. You can present your case out of order, or once we finish with Mr. Cohen, we can adjourn to tomorrow morning. The witness has to be here by 9:30. The witness has to take the stand at 9:30. If it doesn't happen, we're going to proceed. And after the people rest and you put on your case, we're going to have our charge conference. What we discussed this morning and the plan that we came up with this morning and agreed to remains the same. After tomorrow, after the charge conference, you will get proposed jury charges, I believe, Thursday. Hopefully, we'll be adjourned to Tuesday of next week for summations. Sorry, for summations. There is no prejudice to anyone. May I have 2 minutes to talk to my team and my client? Sure. I think we may be able to move this proceeding along. Tell me. I think, if I understand what we agreed about, the exhibit will come in through Mr. Cohen. We will not call a paralegal and will agree to the following stipulations. The parties have agreed that the people's exhibit is a still photograph and further agreement here. Then we'll put the exhibit in through Mr. Cohen and we'll read the stipulation. And then the exhibit won't be coming in for a timestamp on the exhibit, but for the stipulation, we'll cover that. Mr. Blanche, you consent to that? Yes. I understand it's a strategic decision. Have you discussed this with your client? Yes. That's fine. With that, all of that trouble that they went through, everyone, and Mr. Blanche stipulated to allowing the evidence to come in. So they did not have to call the C-SPAN person. All right, with that, I will go ahead and stop the reading for tonight and turn on comments so we can finish up with a Q&A. Thank you all for your time. I appreciate that. Things got a little bit yikes. Hello, hello. Welcome, welcome. Good to see you. Yeah, that was a wild ride. Oh my goodness. Oh, thank you so much for the gifts, everybody. Thank you very much. It's true. I think this trial has been, I think, 3 toner cartridges. Oh my goodness. Yes, good evening. Good evening. Welcome, welcome, everybody. Yes, this was a really big read. I had really hoped, everyone, we could have made it through, but we only have a few pages left. So I think that will be fine. I think I'll be able to move on because I really want to get to Mr. Costello. We will definitely get to Mr. Costello in the next live, everyone. So we might just have a few pages and then we will dive into Mr. Costello because that's really fascinating. What am I going to do when this is all over? Oh, it'll never be over. I'm already prepping for Florida, everyone. There's a lot of updates coming up for Florida, so I think we'll be okay. Once we get through the testimony here, which will be very interesting. Oh, my goodness. Once we get through this, then we still have quite a bit to review. But, of course, we do have the Florida case, which I am working on getting prepped and updated on. And I think by the time we work our way through what is going on in Florida, we should hear something about DC. So I think we're in pretty good shape. Yeah, I think so. What's happening in Florida? Oh, well, we're getting it sorted out. Yeah, there's plenty. Menendez and Alito style. Yes, I saw that. So Menendez is still in trial. I think he was actually in trial today, is what I had read. So very interesting situation. When is Florida? So coming up. I need to make it through Costello's transcripts. And then immediately following that, I am going to come back and start getting into the Florida case to kind of get all of that sorted out. So I'm not sure exactly when that's going to be. I'm not sure if I'm going to be able to go live tomorrow, or Saturday. Usually I take Friday and Saturday off, everyone, and then come back on Sunday. So I think I'll probably do that. Just because of how my schedule is working. So we'll have to see. Thank you for your readings. Oh, absolutely. Stipulated to the evidence, absolutely. So the problem was, right, with the evidence was Mr. Blanche was objecting on hearsay grounds because of how they wanted to use the evidence. They wanted to use the evidence for time stamp and date. So that information to prove the truth of the matter asserted would be hearsay. But if they're proving it for something else, if they're proving it just to show that the two of them were together, it's not going to have that hearsay issue, especially if Mr. Blanche stipulates that the picture is authentic. So he basically said, we will agree that this is an authentic picture. So when they were able to do that, then they could get the exhibit in through Cohen, and Cohen could say, yes, these are the two fellas, and this is, they were together at that time. Don't think it's going well for the prosecution. Oh, I don't know. I don't know. Oh, I'm not sure. Every piece has its, well, absolutely. It's, yeah, I mean, you got to fight. You got to pick your battles, but Mr. Blanche, I think, was starting to definitely get in the swing of things there. But I tell you what, this Miss Hoffinger, I'm not going to say her name incorrectly, and I feel terrible about it. Hoffinger. She is just amazing. She is just one heck of an attorney. I'll tell you that right now. A very, very talented attorney. So she's doing an amazing job. Hard to follow sometimes. It's hard to follow most times. Absolutely. Costello seemed to just help Cohen. Well, yeah, and I'm very interested to really get into Costello. I thought it was important to kind of lay out why he was even called. He was called in because of this, questionable interaction that he had with Cohen. But, now that Cohen says it's all been waived, then there you go. Is Cross feistier than usual? How does the jury take this? No, I don't. I think Cross is we're in a very adversarial system, right? So our goal is to fight. That's what our training is. That's our field. And because it's so adversarial, that you're going to hear some fighting going on. And a cross-examination, I think for our jury, they recognize that that's part of it. So, and it's explained too. It's like, it's our job. we have to be careful. We don't want to come off as a jerk. I mean, you have a fine line that you have to walk between being a good fighter and being a jerk. And so, you really have to walk that line on cross-examination. Yes, yes. So knitting to this is prime web time. Oh, that's so fun. Oh, that's so fun. Oh my gosh, that's such a skill. So yes, I have been posting on my Tube of You, everyone. I have been posting every day. So I'm just about, I think I've got my third piece of Mr. Cohen's transcripts due up later today or first thing tomorrow. So the next few days, I am trying to get one posted every single day. So standing for the jury. Oh, absolutely. Absolutely. I mean, it's just basic common courtesy, right? It's the least we can do to say thank you to people who are called in. I mean, imagine being called in for jury duty and like getting put on a jury. It's nobody's favorite thing in the world, but it has to be done. We have to have that. And so the least we can do is stand and say thank you for your time. The least we can do. Yes, yes. Yeah, Florida summary, please, coming up. So what I will do, again, I'm still, it's quite a bit of work, everybody, trying to get Florida sorted out because we've got a whole bunch of documents that have been released, essentially have been, a whole bunch of them had been privated or made private, and so now they've been made available to the public. So what I'm doing is I'm pulling out all of the documents, and so what I'm wanting to do is go through each of the documents that are now made available to the public, and I knew there were going to be several batches of them, and so it's taking me a little bit of time to gather everything. I will do a post specifying the date and time when I will start doing Florida updates, because it's going to take me a few posts in order to do that. Is that abnormal? No, not when you've got a kind of a classified information or you've got a lot of really private information kinds of cases. It's not. No, I don't think so. I think the only thing that's really abnormal about the Florida case is just we've got a baby judge involved. We've just got such a green judge. It's not as smooth. It's a bumpy ride. It's a super bumpy ride involved. Evidence ruling was perfect. Door open for appeals, closed with Blanche's concession. Exactly, Frank. Excellent point. Right. So they're not going to be able to contest the C-SPAN evidence because it was stipulated to, and the stipulation was actually read into the record, so which I think is always great. So, but, it sounded like Blanche wasn't really contesting that issue either. I think he was kind of going for like the quick and dirty hit on cross as opposed to the actual substance to the hit, if you know what I mean. I don't think he was going after, this big mess that Cohen was like, oh, wow, this was awful that you screwed up this particular understanding. I think he was just trying to go quantity over quality with Cohen. How many times did you not tell the truth? How many times did you screw up phone call dates and times? And if you add them all together, your credibility is done, as opposed to this is really important. You really should have remembered this, if you can follow me on that. So green judge, yeah, she's just a baby judge. She's a baby judge with almost no experience on an incredibly important case. And so she's, she just doesn't have the polish. So she's just kind of fighting her way through this whole process. Goes, oh, thank you, robot. Yeah, just, she just doesn't have a lot of experience. And, with this kind of a case, they got to get their start somewhere. And isn't this the worst possible place? I mean, that statement is so true. But for the rest of us, it's like, but we don't want you to cut your teeth on this case here, ma'am. Yeah, they draw judges. It's possible for her to be removed, but she has to make a mistake. I mean, she's got to make a mistake that rises to that level. Right. I mean, she can recuse herself, although her credibility then will always be in question for the rest of her entire career as a judge. Or, it's possible for her to be appealed or for the higher ups to be like, we need you to step back. But, again, her credibility will always be on the line. Judges speak with their colleagues for advice. Absolutely. Absolutely they do. Absolutely. They need to constantly. she should have recused in the beginning. That's a good point. I think if she had recused earlier, that would have been a different situation, but she's definitely too far into it at this point. Any areas of appeal for the hush money case? No, not yet. I haven't seen it through the transcripts, through the evidence that I've seen. I've not seen anything that's risen to the level. I think they're going to ask for it. I mean, Mr. Blanche is asking, every other day for a mistrial, so that he can kind of put his bookmark in where he wants to appeal, which is fine, which is what you're supposed to do. But I haven't seen anything at that level. Is there a mentorship program for new judges? How do you learn to be a judge? Great point, Kali. And you learn to be a judge by, you just get thrown in. You get thrown into the deep end and you sink or swim, and it's awful. I mean, that's kind of the legal field. We do have some mentoring and we do have some assistance that comes in, but in the legal field, it's the practice of law because we're practicing it. And when you practice something, you're going to mess up. You screw up a lot. And, it sucks, but that's just kind of part of it. You've got to stumble your way through, and it's based off of those mistakes that you get better and better and better. So you screw up and then you figure out, the judge yells at you and, you figure out you're doing something wrong, or, you screw up a case so bad that you just, stay hidden in the basement for a week. I mean, it's a career of humiliation, everyone. You learn through humiliation repeatedly. So unfortunately, Mershon's got so much experience. I can't think of any reason why any of the New York judges would recuse themselves. They're so experienced. There's no way. Texas state courts have baby judge school. Well, that's frightening. That scares me a little bit. I'm a little worried about that. Yikes. But it's hard. It's hard because you make a lot of mistakes and you screw up. But the thing about the legal system is you can make mistakes, but you can also clean them up. You can screw up, but come back and then you have to fix it. You own it, and that's one of the things about Michael Cohen is he's like, dude, I really messed up. I need to clean up this mess I made, and that's part of the legal field is that we go in and we kind of clean up the mess. Texas justice. Well, Trump's attorneys are they don't really clean up any messes because they don't think that they make any messes, which means they think that they're above the process, and that is quite disturbing. That's unfortunate. For a couple of weeks before taking the bench. Yeah, I mean, it's yikes. We have things like that for all of our judges and all of our systems where, it's like they can go and hang out with other judges and stuff, but there's nothing that I think could have prepared for her there's no way that she could have been prepared for this kind of case. The only thing that could have prepared her would be years of experience. So yeah, great sketches. Oh yeah, the artists are amazing in all of this. Absolutely amazing. Yeah, no, Navy vet, no, don't say that, no. We don't want to go down that road. Judge Mershon, yeah. So again, it doesn't matter. Who cares? I think several of our judges are born all over the place. That's so what? Who cares? That's what American is. American. We're a mixed bag here. So it doesn't matter. The Constitution sets out how you can become a citizen. Once you're a citizen, you can be a judge, and that's how it works. Doesn't matter. Yeah, it doesn't matter. Oh, I know. Okay, right, everybody. So listen, I have to tell you this. I'm telling you right here, best sketch ever. Right here. We've got the side eye from Mr. Costello, and then Judge Rashad's like, what the heck are you doing? What is happening here in my courtroom? Oh my gosh, it just cracks me up. It cracks me up. Yeah, it's funny. Why didn't the judge ask Trump if it was his decision not to testify? Opens opportunity to appeal. So, he doesn't have to. The thing is, you just follow the rules. You don't have to follow extra rules because Mr. Trump is like fussy, Like there's just rules. We have rules. We follow the rules. If you want to testify, great. If you don't, great. We don't, whatever rules they follow in New York, those are the rules that you follow. And if Judge Mershon didn't have to get some kind of, formal, like, I choose not to testify. We don't have to. He doesn't have to. He just has to follow the rules. He doesn't have to follow the fussy Trump rules. Oh, my goodness. He'll be able to vote for himself in Florida. Well, yeah, but I mean, come on. He hasn't really been voting that much anyway, except for in the last couple of elections, I would imagine. I'm guessing. I'm just guessing, everyone. Don't come for me. I'm just guessing. He doesn't seem like he's a big voter to me in the past. I don't think in the 80s Trump was like, ooh, who am I going to vote for? Yikes. Getting lined up. I just don't see that. Yes, he can become president. Yeah. We just don't know. I mean, we don't know whether or not it's cooked or not. Yeah, we'll have to figure it out. So this case is all about, benefit to his campaign, which is an illegal act. You've got to declare that stuff, and then falsifying records in order to cover it up. Yeah, felon for president. Well, yeah, it sucks. Used to be a Democrat. Well, who knows? Come on. we don't know. We'll see what happens. Thanks for what you do. Oh, you're welcome, Professor. Good to see you. I'm happy to do it. I'm not sure if I see it win. Well, truly, it's 50-50, everybody. It's a 50-50 shot in front of a jury. We don't know. We can take a look at it. And at the end of the day, the best we can do, and this is how I always felt when I walked out of a courtroom at the end of a trial, was I left everything on the floor. I did everything I possibly could. I didn't keep anything in reserve. So if you walk away from your case and you're like, I did everything I possibly could. I played the full show, the full, vaudeville act. It was all 100%. I give 120%, everything I had, and I left it on the floor. And then you walk away when you leave the courtroom. And I feel like for the prosecution, what else could they have done? What else could they possibly have done? Maybe a couple of things here and there, but I feel like they put on the best show they could put on. Is it enough? I don't know. Did the defense put on the best show they could? I don't know. I don't know if they kept a little bit back or not. It doesn't feel like the defense put on their best show, but they didn't have much to work with. But I'm not sure that, they don't really have to go at the same level, but for me, whenever I left the courtroom, I always wanted to say that. So I say that to myself, and I had to as I got in my car and walked away. There would be times when I get home from work and I would just be sitting in my car. I would just be so exhausted. I couldn't even get out of my car. I was so tired at the end because you just kind of go through this weird decompress, and it hits you when you finish trial and you walk away. It just hits you and you're like, wow, okay. Wow, it's been 2 months. What's been going on? And I just remember I would sit in my car and my significant other would come out and he would just grab my briefcase and he'd open the car door and he's like, are you hungry? And I'm like, I think I am. I think so. Because you're just done. You're just absolutely done. And if you can leave it all there, you leave it all out there, then you're good to go. Unanimous, yes. Criminal decisions. Our criminal verdicts. Yeah, those are some rough times. Yeah, adrenaline is so true. It's so true. That adrenaline gets you going, and it's like you wake up again when you finish. You're done, and you're like, wow, hello, and who are you? I forgot who you are. It's required. Yes. You've got to have a unanimous criminal verdict. Yeah. Yep. Great question. Don't allow convicted felons to run for roles. Right. Well, and that's the thing is, we're only a couple hundred years old. We're kind of, we're still getting stuff sorted out. We got this Constitution that's still got, we got some cleanup on aisle 4 with that Constitution a little bit. We got a few things that could use a little bit of work. So we're still, I know because we've done a lot in a short period of time, but in all honesty, compared to the rest of the world, we're still figuring it out. Wesselberg, I think Wesselberg was a double-edged sword. I think it could have been very helpful, or he could have thrown it. I mean, he's got nothing to lose. And honestly, I bet they think he would have just taken the fifth, and that would have been smart. That would have been smart. He would have come in and he would have said, I plead the fifth. I will not incriminate myself. Like, he's in jail. Like, I'm not going to incriminate myself, so forget about it. Do you ever aspire to be a judge? No, I did. You know, I did in the beginning, everyone. I had, you know, I had the goals. I had the big goals. But, you know, I think and judges have been there for a really long time, usually. I mean, or the baby judges. But it's exhausting. It's exhausting mentally. And for me, I couldn't sustain it. I could not sustain that level of adversarialness. You know, I was just angry all the time and fighting all the time. And sometimes you realize, like, are we fighting over, you know, what we're going to have for dinner? Like, do we need to fight about that? Because you forget. Sometimes you forget. Like, I don't have to fight about everything. And it's exhausting. And it takes a lot out of you. So, you know, I've got nothing but respect for it. But I also recognize in myself that I just don't want to fight all the time. So I had to take a step back and reassess, you know, myself, which is, you know, what everybody should do. And I'm thankful for those that did. Yeah, people are tired. It's so true. It's true. And I think our tiredness hits us at different times. It really does. It hits us at different times. And yeah, so I think it just happens. But I respect, support the system. I know there's problems. I'm, you know, happy to share my knowledge with others. But yeah, I was just, you know, I reached a point where I knew I was losing. I was losing more than I was winning with my own self. So I was just turning to a point where I didn't care much for where I was going. So blew up at some point. Yes, he did. He blew up during that part when he was saying to Cohen, like, well, you're lying, aren't you? And Cohen is saying, no, I did both things. And he's like, well, that's not true. You didn't speak to Trump at all. You're just lying. And so that was, you know, that was the moment where he made it a really big deal. Could take it on all. Exactly right. I mean, we're in a relay, everyone. You got to kind of pass the baton off. And then when it's your turn, grab it again and then run for a bit and pass it back off again. But you can't run the whole thing yourself, I guess. You know, it's just too exhausting. It takes too much out of you. Yeah, the threats are a lot. Wendy's or McDonald's? Well, Wendy's, of course, right? I have a special spot for Wendy's because I worked there when I was very, very young. Yeah, I know. I worked at a Wendy's, yeah, but I was too short. I wanted to be a grill girl because nobody else my age and my gender was on the grill. And I'm like, I'm going to make the burgers. If I'm going to be here, I'm going to make the burgers. And they're like, we can't reach the back of the grill. I'm like, so I stood on a milk crate so I could reach the back of the grill. Oh, memories. Yeah, I'm 5'2". I'm petite. What were the accusations against Cohen's wife? I think there was some, there was some worry that Cohen had that she was going to get pulled in, that she knew about what was going on too. So that's my understanding from Cohen's transcripts and from different things that I've heard him say. So it wasn't necessarily that there were full charges, but he was afraid of that. It was his fear of that. And there's salt to keep it from caking. Well, yeah, I mean, yeah. Yeah, exactly, short girl. 5'3", I know. Oh, I know. Chili's baked potato. I know, everybody. I know. See, I know. I tell you what, it's hard work working fast food. That's the hardest job I ever had, was working in fast food. That is hard work. Will Justice Alito recuse himself? No, he's too full of himself to recuse himself. you know, you recuse yourself in the interest of justice. You don't recuse, and I'm not sure that that's his goal, especially after a couple of the cases that came down today. So, yeah, 5'2", yes. Oh, I know. Chick-fil-A, oh my gosh, I know. That's hard work. People don't realize how hard it is to work. And you're like under pressure, like you got to get that burger done in like 60 seconds. And if you don't, you know, bad things happen. It's bad. It's really tough. Sometimes I still, in my dreams, hear the drive-through beep. And I'm like, hi. Like just, oh my gosh, I know. Oh, 25 years. Wow. Oh my gosh. Oh, Taco Bell. Oh my goodness gracious, everybody. That's hard work. Like I have nothing but respect for people working in the fast food. I mean, that's tough. That's tough. You're fun-sized. That's true. Oh, fun-sized. It is hard. It's super hard work. So yeah, I agree. Oh my gosh. Yes. And the drive-through buzzer every once in a while. Yeah, you get it. And oh my gosh. But I can make a mean burger. All right. So we got Memorial Weekend coming up and I'm the one on the grill. Chief Justice let that go on. You know, I think he does. I think the Chief Justice is doing the best he can right now, but the best he can really isn't that great. I think he needs to have a, you know, he needs to have a talk to himself. He needs to look at the man in the mirror. Chief Justice does. He needs to have a couple of minutes. Oh, can you come over? Oh, that's so fun. Yes, well, where he got. Get the grill going. That's the one thing about working the grill when you're that young is you just go and you can grill the rest of your life. Yep. No, I'm happy to grill. I remember my significant other when we were first getting together was like, oh, let's have a barbecue. And I'm like, what are you even doing? I don't like, get out the way. You're just in my way. Oh my gosh. He was. Oh, bless him. He was very understanding. Oh my goodness. Yeah, Roberts, I know. Yeah, something's gonna break, everybody. Something's gonna break. Something's gotta give. I know, Thomas. Oh my gosh, yeah. Oh my goodness gracious. Yes, well, yeah. So, and if you don't want to grill, or if you're, you know, tofuing it, go for it. You know, whatever, go for it. I fully support all of the options out there. We'll go into deliberating. So we've got summations coming up, and then the charges is what they call it in New York. Jury instructions are given. So we probably got a couple of days at the most. So I would say that they would start their deliberations. So they're going to be coming back on Tuesday. So I would say Wednesday. Yeah, Wednesday. I think you're right, Ms. Donna. I was like, Madonna, welcome. Yeah, I would say Wednesday. Tofu on the grill is great. I agree completely. I agree. I was vegan for many, many years. Enjoy a good tofu. What if there's a conflict between the justices? Well, they have to argue it out. That's the thing, is that there's a lot of actual negotiation that's going on, especially right now, because, you know, if you look at the decisions that came down today, the splits are really weird. Like one split's the classic. We've got the conservative judges on one side and then the liberal justices. But then we've also got another case that came down where they're split all over the place. And it's like, what? Why is Gorsuch in there? Like, what's he doing? So it's kind of weird. It's kind of a weird situation going on with that. So yeah, I'm not really sure exactly yet how all of that's going to happen. Thank you, Tova. I appreciate that. Yes. Well, he's a bit snarky. He's got a bit of snark to him. In my opinion, yes. my humble opinion. Yeah, I agree. So yeah, the Supreme Court's gonna need to. They're gonna have to have something's gonna happen here. I feel. Caramel onions, ooh, fancy. Yes, on the red bubble. Oh, I'm so glad you loved it. Oh, good. Thanks for coming by. I appreciate it. Right. Well, right. And that's the thing is it's a mixed bag, and there's nothing wrong with it being a mixed bag, but it makes it tough to try to get your grip. So the problem is there's really no way to predict what's going to happen. And I think with that, there's just this overwhelming sense of uncertainty. Yeah. Yeah. We've got Memorial Day coming up on Monday. So that's why we've got a big weekend. How do we get them to recuse themselves? That's a great question. Great question. What side-eye? I know, right? Look at that side-eye, right? And Just Rashawn's like, what the heck is that? What are you even doing? Oh my goodness gracious. Yes, it's cracking me up. It's absolutely cracking me up. I know. Oh my goodness. Yep. You got it. Negotiation, the judges. I have not printed everything out. I've got one more batch I need to print, so we'll have to see. Frank, I'm not sure about that. That's a good question. It seems like that should all be on the record. And if it is, that'll be fascinating. I think that's really interesting to figure out when they hammer those kinds of things out. So I'll take a look for sure. I'll take a look and see, and if they are, I'll do probably a special. Now, keep in mind, everyone, I fast forwarded through a lot of these transcripts to kind of get us to this point because I wanted to get us to Costello so we could keep moving. But I will probably be doing some intermittent, shorter lives to kind of go back and cover some information because there are some good things in there too. There's a whole bunch of stuff about the Cuomo fella involved, and I'm like, I should talk about that, but we just ran out of time. So but I will come back and I'll be doing little snippets, possibly Saturday afternoon. It's possible. Yeah, it's possible. I would think I'm gonna try, definitely. Well, I probably won't be back tomorrow, but I might be able to come back on Saturday. We'll have to see. I've got to see how, I got to get the grill ready. No, his brother, there was, I think his brother was involved. So anyway, yes, I will post everyone and let you know when I will be back live very soon. So now there's no assaulting going on, unwanted touchings. No. Oh my gosh, Roger Stone 2.0. Oh my gosh, yes. Marinate the meat, of course. Of course you have to marinate. Oh my goodness. Yes, the news anchor. I think so. So I will put a post up letting everyone know when I come back again, and make sure to tell everyone when I do Costello. So that'll be a really, really big one. So I'll make sure to tell everybody plenty of heads up on that one. So with that, I will go ahead and sign off for tonight, everyone. Thank you all for coming and hanging out. Thank you to the moderators. As always, you're amazing. Thank you so much. Good night, John. I stayed out of the hole tonight. Yay. So have a wonderful night, everyone. Happy Memorial Day weekend. But I will see you all very, very soon. Take care, everyone.